We are the Florida versus James Colley case, a domestic violence, double murder, capital murder case. The state is looking for execution, and I have the honor and privilege of being on with our guest today, Ashley Willcot, who not only is a trial attorney, but she is a juvenile justice judge as well. Welcome to the show.
Thank you, Bob. Nice to be here. Good to see you.
Great to see you. So listen, I was just telling our viewers, and I know based on your experience, certainly as a judge and as a trial attorney, that, you know, there's so many of these cases where typically women, but it can be men too, are looking for protection of the court. They go to the court. There's a little concern that they may exacerbate the situation by doing that. And there he was that very day getting an order, or she was there that day getting an order of protection, which apparently, based on the father's statement to the police, got him extremely agitated and led to this particular killing. But what are your thoughts about this whole thing with the scourge of domestic violence? And I used to say, Judge, today's domestic violence is tomorrow's murder. Be careful, prosecutors.
Absolutely. I agree with you. So that's the double-edged sword. The best that we can do is offer a protective order that the court signs, issues, so they have at least a piece of paper to say, if these people come to harass me, bother me, threaten me, I can call the police and they can be removed and they're no longer a threat. The opposite side of that, and the problem is, if someone really wants to get to someone and murder them or hurt them, they're going to. And you're right. In this case, it agitated him as he was exceedingly angry after he left that hearing, and then he took his next step. So I don't know what the answer is. It's really a tragic situation where she tried to do the right thing, ended up getting murdered.
Yeah, Judge, you know, another thing, too, that I found was interesting in this case is the state is rested, but the mother and the father of the defendant provided evidence to the police. Mother basically saying that he blamed Ms. Dobbins for basically getting his wife to step out, if you will, away from him. And also, he was very agitated by the fact the father talked about the court hearing. Interestingly, and he said he was very mad and very angry, and that's where he got the gun. But the state didn't put those two witnesses on. Did you think that that was an interesting tactical move?
You know, it'll be interesting to see why not, right, and what those two individuals knew. And I don't know why they may not have called them, to be honest, because it's just two more pieces that paint the picture and the two more pieces to the puzzle for the jury to say, okay, here's everything all together. So I don't know. It's going to be interesting to see what their theory is behind that.
Yeah, I agree. Well, listen, Judge, stay with us because we are going to go back to this riveting testimony from Rachel Hendricks, who was actually inside the closet and was grazed by a bullet when the defendant shot through the closet, and ultimately he went in and murdered Ms. Dobbins. Yeah, so this is the James Colley case. It is a capital murder case. 2 people were shot and killed. He's charged with all sorts of bad offenses, obviously. And we have Ashley Willcot with us, who is a juvenile judge as well as a trial attorney. So, Judge, you know, I love the kind of testimony. And when I say love, I say that as a prosecutor, as a lawyer in a homicide case, where you have a person who's actually narrating a story that escaped a murder scene. I can't remember myself being involved in a murder case where somebody actually escaped as a witness and is able to give this impactful testimony. What do you think the value of that is for the prosecutor in front of the jury?
Huge value for 2 reasons. One, like you already mentioned, she's going through painstaking detail to paint the picture for every little piece of what she saw, where she was, where she parked, what happened when she entered. And that paints a very vivid, believable, credible picture. The second piece of it is her emotion, right? This is the emotional tug on the jury's heartstrings to make them feel like they were there, and what not only this victim experienced, but also more importantly, what the victims who are now deceased experienced. It's invaluable from the prosecutor's standpoint.
Yeah, and I'm not really hearing much in way of kind of mitigation, if you will. Now, like I've always said in a death penalty case, and having tried death penalty cases myself, you know the defense wants to at least find one juror, just one, that can't agree with the aggravating factors and hopefully spare the life. Our public defenders that we used to try cases against, Judge, were very, very experienced death penalty litigators, and they always said to me, Bob, this is me prosecuting, it's about keeping them alive another month, another day, another minute. But this kind of testimony from this kind of witness could probably not be very good for them in the penalty phase.
That's right. And so I think what they're going to have to do is utilize other evidence, obviously, and other cross-examination to really try to get some of the jurors to feel more sympathetic towards the defendant, because this particular witness I find credible and believable, and I think it's going to be hard to take much away from that by the defense.
Yeah, and I don't think that it's beyond the jurors when they humanize a witness like this to realize the kind of environment that she was in and what was going on and how she and the man escaped with their lives. You know, she's literally in a closet being shot at, grazed by a bullet, has him come in, walk past her in that closet, and then execute Ms. Dobbins. I mean, any juror is going to look at it and say, can you imagine if that were me?
Right, and the terror, and I've described this, I've listened to all of her testimony, and I feel like it's a description of somebody who's being hunted. And so I do feel like that emotion for the jury is not going to go away regardless of what the defense presents.
Well, listen, this is the Law and Crime Network. You've got to love this kind of coverage because you get somebody like the judge there or myself who have actually been in the courtrooms doing these things. It's a Dan Abrams production. We are gavel to gavel coverage. I go real quick, Judge, because there's so much to talk about in this case.
Absolutely.
And our producers have been awesome to us because they told me as a gift they're going to allow us to listen to most of this testimony from Rachel because it is riveting testimony. And our viewers, I love them. Ask those questions, folks. And if you have a question for me or the judge, we'll try to answer it. And you are here again at the Law and Crime Network. Judge, if you wouldn't mind, stand by. And on the other end of this, we're going to come back with some of this most powerful testimony that we have in the State versus James Colley case. Okay, welcome back. My name is Bob Bianchi. I'll be hosting till 5 o'clock today in the Florida versus James Colley case. It is a death penalty case. The state has rested. The case went in pretty quick for them. I'm with Judge Ashley Willcot. We've been talking a little bit about the case, and we're lucky enough that we're going to be able to listen to really the meat now of Ms. Hendricks' testimony. This is the riveting stuff. Hey, guys, when you're watching this, think about it. If you were sitting in that jury box and you were listening to this kind of testimony, one, I think that it would have a great impact upon you just thinking that maybe this could have been me, and two, it's not going to go well for the defendant either in the guilt phase or what I anticipate will be the death penalty phase of this case. We'll talk to you on the other end of the clip. I'm Bob Bianchi for the Law and Crime Network, and we were listening right there to Rachel Hendricks, who was an actual victim and a witness, now a compelling witness for the state. And I'm with Ashley Willcot, who's not only a trial attorney but a juvenile justice judge. So there was the meat of her testimony and very powerful evidence for the state, describing this whole argument with Amanda in the bathroom, and she's, you know, in the closet, and just so the viewers know this, when the defendant is saying, where is he, they're talking about Lamar Dubberly, who had earlier received a picture mowing the lawn of his estranged wife with his shirt off, and that is the person that actually was at the house and also escaped. Judge, you got a lot of activity going on here and a lot of compelling motive.
Absolutely. So one of the things the prosecution's doing really, really well is they're laying out not only the testimony, but note that they're using the pictures. So the jury gets to see exactly what the ransacked bedroom looks like and the reason why the wife called her to come help her clean up in the first place. They're getting to see the actual closet where she hid with the other individual who was then shot and killed. She gets to see the bathroom, or the jury gets to see the bathroom where she was hiding the wife who was then killed. The other thing I'll just point out is it is interesting, isn't it? The testimony is that Lamar, she said, what is that? And he said, that's gunshots. He took off and left through the garage.
Yeah, for sure. Well, you know, when bullets fly, chivalry sometimes goes out the door, Judge. You know
Fair
that.
enough,
Well, listen, I mean, yeah, this is really unbelievable testimony. And what I liked about the prosecution's technique is what we call looping a little bit, is where they're getting the direct testimony out, but they're reinforcing the testimony again with the use of demonstrable exhibits like those pictures. Judge, you've seen lawyers do it sometimes. They go in very antiseptic. They show the picture, the person gives the testimony, and they're really not animating that testimony in front of the jury. But by using the pictures, as you've indicated, the prosecutor's essentially getting testimony out twice about the most important parts of this case, the sizzle, if you will, the actual crime itself.
That's right. Not only that, but I think it's really effective in this case because notice that this victim, I'm not at all suggesting it wasn't horrific and traumatizing, but note her testimony. She's not super emotional, right? And so she's not crying and reliving it. And so I think that that technique of looping that you've described is really effective when you have a witness who's so calm and collected in spite of what she's been through.
Absolutely, Judge. I was noting that myself. Very well prepared witness. But we're going to go to a break, Judge, and on the other end of that, we're going to come back with some more testimony, more discussion. Thank you. I love that picture, Linda Kenny Bodden. I mean, unbelievable. She's a great guest. We have her on here, but we have another great guest, Ashley Willcot, who's not only a trial attorney, but a juvenile justice judge, and you can tell she's the real deal. People on the chat rooms love you, Judge. I can tell you already, based on the commentary we're getting. And I love being able to have somebody like you on because we could talk about the nuances of trial law, which I think our viewers really like. And you were making a comment about the demeanor of Ms. Hendricks as she was testifying in a cool, calm, and collected manner. And I also noted calling him Mr. Colley as opposed to the defendant or a first name. You've seen it as a judge. What's the good, the bad, and the ugly in terms of a state's witness? Like, what do you really want in a state's witness to make the most impact?
Sure. Well, let me say this. I've seen all ends of the spectrum. And so the important thing is, number one, by saying Mr. Colley, she's personalizing the defendant. So it's not just a random person. It is that specific defendant right there in front of the jury. And that personalizes him for the jury, which is really important. The other thing is you can tell that her testimony has been well prepared because she answers very succinctly, directly, yes, no, then describes. And so it's really easy for a judge and jury to follow along with that kind of testimony. I can't tell you how many times I see testimony where the victim, or excuse me, the witnesses haven't been well prepared and it's kind of all over the map and they're not sure what they're being asked and they're not sure how to answer. And that can be really exhausting to the jury as well as to the court.
Yeah, that's a great point. And, you know, listen, when you're preparing witnesses, folks, like the judge knows and noted, you don't want them to change as people, and you certainly don't want them to change their testimony, but you want them to be prepared. You want them to know the roadmap of where you're going, and you want them to be able to answer the questions honestly and succinctly. But you know what, Judge? Like they say, you dance with the one you brought sometimes, and despite all the pretrial preparation you can do, sometimes the witnesses get on there and information's coming out you never heard before, or with the pressure and the intensity of it, they don't necessarily come off as well, or sometimes even better than you thought they would have.
And like you said, they are who they are when they get on that stand. But the most important thing is that they come across as being truthful and honest. One of the things I also see, and it's not happening with this particular witness, but the drama. So if you have a witness who's very theatrical or overly dramatic, I think that can affect the credibility in the jury's eyes. Now, that's not happening here, but I've certainly seen it happen.
Absolutely. Judge, great insights. We are here at the James Colley case, and after this testimony, we also had testimony, Judge, of Mike Pickens, who's a neighbor and supposedly the defendant's best friend. Let's take a listen to a little bit of this testimony. I found it interesting the state intended or decided to introduce it, and come back on the other end and see what your thoughts are about that. Well, welcome back. I'm here with Ashley Willcot, the juvenile justice judge as well as trial attorney, and I'm just going to ask you a general question. Was some of this testimony confusing to you in the manner in which the prosecutor was asking those questions, Judge? Well, I'm not sure if Oh, okay. I'm sorry. Unfortunately, we're having some technical difficulties with the judge, but really what that is preparation, anticipation. She's actually making us wait for this riveting answer the judge is going to give. And it really is an important, issue in the case. If you were watching what was going on, and our producers will let me know when we get the judge back on, but if you were watching, it seemed as if he was saying, no, I don't remember those texts, I don't remember those texts. So he's an important witness, I guess, in a certain sense, and I don't think he hurt the state's case. I just found it odd and peculiar in the manner in which this was being done. So we are here at the James Colley case. This is a double homicide case. We've already listened to Rachel Hendricks' For those of you who are joining us, she was a riveting witness who was inside of a closet. She was actually shot at and grazed, and then the defendant opened the door and killed Ms. Dobbins, and that was after he already killed his estranged wife. And I'm being told through the magic of the earpiece that the judge is back with us. Judge, are you there? Can you hear me?
I'm here.
Okay,
Sorry about that, Bob. You cover well.
All right, Judge, we got 1 minute. So I'm dying to hear that answer again about the way the prosecutor was asking these questions of the witness.
Yeah, so to me, he came off as a hostile witness. You saw he was chewing gum, leaning back. I don't remember that text. But the importance of this witness is this to me as a judge. That is the fact that this defendant planned it. His state of mind that it was premeditated, because this goes back to when he ransacked the home and they're building up to say he had the state of mind for premeditated murder.
Yeah, I don't disagree with that, but I got to wonder, because the prosecutor's got a slam dunk, in my opinion, on premeditated murder from the evidence, whether or not they may have put in a little mitigation evidence in there in terms of this, maybe not necessarily a strict passion provocation defense, Judge, but that the guy was agitated, he was angry, he wound up in court. I'm not saying it justifies it, but it very well may get one juror to say, I'm not going to impose the death penalty. We're going to go to a break, and on the other end, hopefully the judge will still be there with us, and we'll analyze this case further. Well, we are Florida versus James Colley. The state has rested its case. I have the honor to have Judge Ashley Willcot with us. We've been breaking this down, and we got some top crime stories, Judge. And on the other end, I know we got 2 or 3 questions I got to ask you. I'm begging the producers to let me ask you, because I know you're going to give me a great answer. And on the other end, the top crime stories, maybe we'll talk about 1 or 2 of those stories, get back into this case.
Here are today's top crime stories trending on lawandcrime.com and across the country. A woman in Philadelphia was arrested for killing her 11-month-old baby after she allegedly breastfed the child with drugs in her system. 30-year-old Samantha Jones of New Britain Township is charged with 1 count of criminal homicide after the autopsy of her baby, RJ, showed the infant died after ingesting breast milk containing methadone, amphetamine, and methamphetamine. The woman reportedly described herself as a drug addict to authorities, and her other 2-year-old son is in his father's custody. Jones is being held in lieu of $3 million bail. A police officer and elderly woman in Massachusetts were both killed by the officer's service weapon after an attacker was able to take the officer's gun during an altercation. 42-year-old officer Michael Chesna was in a car pursuit with suspect Emmanuel Lopez before Lopez wrecked his vehicle and fled on foot. In the ensuing chase, Lopez struck Chesna with a rock and took his firearm, fatally shooting the officer in the chest and head. According to authorities, Lopez then fatally shot a woman in a nearby residence before being arrested. Lopez now faces 2 counts of homicide. 2 officers in Georgia were caught on body camera footage using a coin flip to determine whether to arrest a woman for speeding. The officers Kristen Wilson and Courtney Brown of the Roswell Police Department can be seen on video discussing whether to arrest or ticket the driver, Sarah Webb, who was doing 90 miles per hour in a 45-mile-per-hour zone.
A head, R tail. Okay. This is tail, right? Yeah. So really, 23.
Webb was subsequently arrested and charged with reckless driving, but the case was tossed once the body camera footage surfaced. The 2 officers were placed on paid administrative leave pending an investigation. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Well, Judge, you know, I want to talk to you about 2 of those crime stories, because I think that they're really important to a lot of the work we do here at the Law and Crime Network, and certainly a lot of the media analysis that I do as a law enforcement expert and having been a chief law enforcement officer. And the first case that we dealt with was the cop whose gun was taken from him, used to kill him and then another innocent person. And a lot of times we talk about when you resist arrest or when you get into an altercation with a police officer, they say, well, the other person was unarmed, not realizing that cops are trained that there's always 1 gun at least in one of those encounters, and that's the officer's gun. And many times the officers are killed in these traffic-related incidents, the highest level of risk for them. And I think that this kind of case underscores that, and you can be assured many police agencies are going to be breaking that case down. What are your thoughts?
Well, at first blush, you hear, oh, the officer's gun was taken and this crime was committed, and you think, what did the officer do wrong? How did that happen? But I do think they need to analyze it, because in this case, it doesn't appear as if he did anything wrong. The defendant used a rock, right, to hit him, to then take his service weapon from him and commit these crimes. So I absolutely agree. They're going to have to delve into this to figure out, was there anything that could have been done differently or not?
You know, when I do a lot of analysis, I try to tell the public, and I did as prosecutor as well, to say, listen, here's how you should handle a motor vehicle stop. Here's how you should handle a police encounter. And you get a lot of pushback sometimes from people like, the cops should know better, they're trained. And I'm like, it's cases like this that the cops listen to, and they want to go home just like everybody else. And this is what's ratcheting up that tension out there between a lot of times the community and the police community.
Absolutely. It's like, it just, follow direction and do it calmly, and they should do the same and we'll all be okay. But this is the exact situation where the police officers are at risk every single day, every stop that they make, every defendant that they chase.
Judge, in your neck of the woods down there in Atlanta, you got this case down here with the coin flip as to whether or not now the case got dismissed, and I guess I can kind of understand that, and certainly the cops should be reprimanded. This is a completely inappropriate thing to do. These aren't laughing matters, but the case didn't necessarily have to be dismissed because she in fact was speeding.
Well, first, how asinine of these cops to act that way. But my understanding is the prosecutor looked at the video cam and then said, forget it, I'm not prosecuting this case. I think because the credibility of the officers is shot. So even though she was speeding, you can imagine the fun defense would have with this particular case with this video cam. So I think the choice by the state was, forget it. If she was wronged in terms of how they handled it, even if she was speeding, we're going to let this one go. So she got a lucky break.
Well,
in that sense.
No pun intended, but this is the opposite side of the coin that we were talking about in terms of police misconduct. And, and I try to say to people all the time, when I've done civil rights work, and I know you are very experienced in police work, and I've done prosecutor work and defense work, it's not as clear cut as you think. Are there temperamentally unfit, untrained people that should not be police officers that do bad things? Absolutely. And yet you have the other case, like the cop that had his gun taken, and we need to do a better job at being not so vitriolic one side against the other side, but actually sit down and say, how are these things happening and what can we do to stop them?
That's right. And look, it's like every other profession out there and every other job. You have the majority of people doing their job, doing it well, and you're always going to have a few outliers that aren't doing their job well or aren't best trained or aren't the best people for those particular jobs. It's no different with cops. So not every cop's going to be perfect and perfectly fit for the job. That's just with every job, lawyers included.
That's right. And that's why if you have an effective and aggressive internal affairs that's meant to protect police officers' jobs when they do the right job, but go after or retrain the ones that aren't doing the right job, you have a far more healthy system. But when it all works together, Judge, when you have good cops, good police work, and you're doing the job out there, you could try to solve cases like the James Colley case that we have going on right now. We've listened to some riveting testimony of actual victims inside the home, the defendant's best friend that we talked about. But there's also the cop piece to this, the forensic piece to this, that the state has to put these witnesses in order to prove their case. And one of those witnesses is a Christine Keegan. She's a crime scene technician, and I found it very interesting with respect to some of the information that she was coming out, having done an evaluation or a crime scene investigation with respect to the defendant's home. And so we're going to listen to that clip, and on the other end of that, we're going to come back and we're going to talk about a little more, Judge, about the placement of these witnesses, why some witnesses, not other witnesses, and whether this witness was effective. Okay, James Colley on trial for double homicide. I've got Judge Willcot with us still. I believe. Okay, Judge. Here's my pitch to you. I'd like you to respond to it. Now, I'm a prosecutor at heart. Prosecutor lots of murder cases. But what I've recently heard is that he was angry and agitated the night before. We had his best friend was called by the state as a witness talking about these text messages where he was angry and agitated. He's in court, and he's obviously angry and agitated. We know that through the father and other anecdotal evidence. He then gets a picture of another man that's mowing the lawn without a shirt on, and the state is now introducing evidence of what I see a cornucopia of gun-related stuff strewn in a very haphazard manner all over the place. Now, I'm not saying this guy's getting off, but I'm just having a hard time as a prosecutor wondering why I would want to be linking all those things together when I'm trying to ask the jury for the death penalty, because I'm thinking this is a lot of passion provocation here. What are your thoughts?
Premeditated. So the reason I think they introduce this testimony when they do is to show, number one, it's a secondary crime scene. And so they're looking at the sister's house where he was staying, and you've got the holster, you've got the gun case, you've got the ammunition. And so clearly it was premeditated. He had to actually either purchase the guns or have the guns, take them out, get the ammo out, load the guns, get the holsters, attach them. So I think all of that instead paints a picture that this was clearly premeditated, because also the chronological timing of the events. This was not something that happened within the course of an hour in terms of all the things you just laid out. They happened over an entire day, night, next morning, and that makes a huge difference in my mind in terms of whether it's provocation or premeditated.
Yeah, great explanation, Judge, but I think that sometimes you can go a little too far with it and it can hurt you on the other end. But listen, we're going to go to a break here, Judge, and we're going to come back. Maybe we'll have an opportunity to discuss this a little bit more on the Law and Crime Network. Welcome back, and we were in the middle of some great commentary and back and forth between myself and Ashley Willcot, who is a judge down there in Georgia and a trial attorney as well. And Judge, you were talking about, I just kind of felt as a prosecutor when it's not just proving the case in the guilt phase, but it's getting that ball across the goal line to get the jury, 12 jurors, to agree beyond a reasonable doubt to not passion provocation, but to actually execute. And I'm not sure whether we lost sound or not right now, Judge, because can you hear me?
I can.
Okay. Well, I can't hear you, but I'll just do a little lip reading here. Essentially, what you were talking about was that they're trying to prove premeditation, and I get that. But I think that they got premeditation throughout all this, because I'm just concerned for them that they get one juror that listens to all of this stuff about the night before and looking at the stuff strewn all over his apartment and the guy that's in the shirt that's mowing the lawn, that you could be building some doubt in one person that says, I mean, yeah, it was premeditated, because you can't get to the death penalty without premeditation, or without a purposeful and knowing murder. But nevertheless, there seems to be mitigating circumstances to excuse or justify the behavior. Now, I don't think that's going to happen, but being a paranoid prosecutor myself in a death penalty case, I'd be concerned about it. What are your thoughts?
And that's what this defense, I think, is going to do. So a good defense attorney is going to grab onto exactly the point you just made. And one of the things you and I talked about, and I see it in a lot of the trials, and I love this network for this reason, so many of these attorneys are really great attorneys in terms of the presentation of the evidence and picking apart as the defense the things that they may be able to succeed on. And so these trials are happening fairly quickly. It's very efficient. They're getting all the evidence in, and then defense has that opportunity. I think you're right. I think they've cracked the window for defense to make that argument that there was provocation. But in my opinion, it's a very, very, very narrow crack, and I just don't think it'll be successful.
Well, Judge, listen. I think I got a lot of what you said through reading your lips, but I can't hear anything you said. But I do know this, Judge. I know that it was insightful, it was on point, it was real, and it was good. But listen, we're going to jump real quick back to Christine Keegan. Christine Keegan is the crime scene detective who found what we just originally started all these questions, all of this gun paraphernalia in the house. And we'll listen to some more information from her. And Judge, when we come back on the other end and I have an opportunity to talk to you, it is my deepest and sincerest and greatest hope that I'll actually be able to hear you. Welcome back to the Law and Crime Network. My name is Bob Bianchi. I'll be on with you till 5 o'clock, and we have Ashley Willcot with us, who is a judge providing some excellent commentary from down there in Atlanta way. Judge, I didn't have an opportunity to listen, but again, I'm gonna add to this on a serious note that we're now introducing the sex toys, if I understand this, that were actually taken from the estranged wife's home, and these were toys that were being allegedly used by her and the man who he was jealous was with her. Again, I'm wondering, I don't know, I'm wondering whether or not it's just adding to this thing where this guy is very jealous, very agitated, very angry, while he may be guilty of a premeditated or a purposeful and knowing murder, whatever the terminology is down there in Florida that they're using for capital murder. Nevertheless, could some juror, I hate to ask you kind of loop real quick again, but could some juror sit there and say, wow, this guy was so compelled to be upset about it, he took the sex toys?
See, I would argue the exact opposite, and that is, again, the premeditated part. He took them. He took them to this house. He put them in his drawer. The next day, he starts with continued activity, getting mad at the hearing. So I think it's a hard argument to win that shows provocation. I don't see it. I don't see it in this case.
Yeah, Judge, we were talking before a little offline, and I'm interested in your commentary on this. I mean, I've been fascinated in the last couple of trials that we've been doing here and viewing the presentation of the evidence and the witnesses from my own experience trying garden variety murder cases that usually take weeks and sometimes months to try, the quickness and alacrity with which the state is putting its case in some of these recent cases. What are your thoughts?
I feel the exact same. As a judge, it's really a pleasure to watch these trials because the evidence is being introduced properly. I teach trial skills all over the nation. They're following all the steps to have the introduction of the evidence and then publish it to the jury. It seems like defense and prosecution more and more frequently on these big trials have actually talked and agreed to what can come in, what cannot, so the objections are limited, which adds to the efficiency of the actual case in court. I'm amazed by it and some of the trial skills I see by both prosecutors and defense.
Yeah, and it also helps to have a judge that starts on time, works through the morning with a quick break, and in the afternoon, because sometimes I've tried cases that have gone for 2 months that should have been tried in 2 weeks for that very reason. But, Judge, we're going to actually go to a break at the Law and Crime Network here. And we're going to go back to more of this testimony. And when we come back, I want to ask you specifically about some of the trial skill issues that you see with the defense side of this case and what it is that they're doing. And are they being effective, maybe not in getting them off in the guilt phase of the case, but actually doing what their real job is, which is to keep them alive for as much of a period of time as is possible. And we know that the state rested today, and they're going to have their full crack tomorrow. But we'll be back with you on the other end of the break. Welcome back to Law and Crime Network. We are breaking down this fascinating trial with Judge Willcot here. Judge, I just want to we got 2 minutes, and I want to do two real quick subjects. And the first is a public service announcement about domestic violence cases. As a baby prosecutor myself, I had a case one time where a guy got bailed out on a DV case. It's not an atypical story. Literally went to his parents' home, got a gun, went and shot and killed the ex. And this is a story that happens all the time. And I don't think it's just enough to have an order of protection by a court with paper. What can they do? People that are the victims of domestic violence and fear of this erratic behavior, people are mentally ill and addicted, to get services beyond that piece of paper from the court.
Right, so get the piece of paper, but obviously there are shelters, and the shelters, the identity, location are not known, and so the individual who is a threat to you cannot find you, does not know where you are. The other thing I'm going to say, and it was true in this case, it's always hindsight's 20/20, if you suspect that person has done anything, whether it's ransack your home, like in this case, burglarize your car, call the police, get out of the home, get away from the car. Don't assume, oh, they did this, it'll be okay. No, you need to protect yourself, get out of harm's way, go away, stay somewhere else, call the police, but report everything to the police. Don't just wait.
Yeah, you see some really erratic behavior. Sometimes some of these characters are like right on a fine line with the law, and they know how to play that game, but it's getting creepier and creepier. You really got to be careful. It's always best to protect yourself and your children, and to be overly cautious, Judge. That was great advice about those shelters, and some of those shelters do an amazing job of keeping your anonymity and keeping you safe. Judge, we're going to also get into our next clip, which is a crime scene sheriff that goes there and actually finds the bodies. Now, I know you've seen lots of homicide photos and autopsy photos in your career. I've actually been on the scenes themselves. You know, it really is emotional when you're going in there and, you do your job, but I think sometimes you back out. Even as a judge, when you're looking at all this in front of you, you do your job. But, I think after a while, it kind of builds up like radiation. It's a little toxic to you, and you back up and you're like, wow, the things I've seen.
Right, absolutely. And I think, unfortunately, sometimes you get a little bit desensitized, not in a bad way, but it's like you see it over and over and over again, and you start to feel like this is just part of our life and part of our society. And the reality is it's, especially those first responders and what they walk in on, what they have to see is really horrifying on all levels.
Yeah, and you know, sometimes some are more jarring than others. I mean, you can get your random ones or dealing with them over and over again, but every now and again, just when you thought you saw it all, and just when you thought that you're target hardened as much as you possibly can be to anything and are impervious to it. I'm thinking of one in particular where a man put a pig mask on another domestic violence case, another divorce action, killed his wife, and that was his way of saying, what I think you're like a pig, and put a pig mask on her face, and you walk into that crime scene. And you try not to be the only guy jarred when you see this odd thing. It gives me goosebumps to this day when I see it. But since I was the boss, I had the ability to say, hey, guys, that was a creepy thing. Does anybody need any help here? Because a lot of these guys do need help, guys and girls that are out there seeing this.
Absolutely. And I think even to add to that, you have so many child victims now. So imagine so many people have to respond to crime scenes where you actually have child victims who have been murdered. So I'm, appreciative you offer the help, because that's what those people need. You got to get through that. That's trauma.
Yeah, and 30 years ago when I started doing this, nobody ever even talked about it. Nobody talked about trauma specialists. Now it's much more of a sophisticated thing, and I think it should go beyond just the cop piece. I think they should do it for the lawyers too and the judges, because we suffer from looking at this horrible stuff. But it is good when you're part of a system that brings justice to families that have had this kind of thing happen to them.
Absolutely. Here in Georgia, we do a lot of secondary trauma training that's specifically for lawyers who do this kind of work, because they've realized and recognized it really makes an impact on that individual.
Wow, I'll have to talk to you about that offline. It's fascinating to hear. So listen, we're at the Law and Crime Network. We're going over the state's cases done in the James Colley case, double homicide, capital murder case. The defense will potentially put a case on tomorrow. I'm here with the judge, and we're going to be breaking it down. But right now, we're going to go to one of those crime scene detectives that discovered the body from the sheriff's officer, and we'll be back to discuss it on the other end. Well, I'm Bob Bianchi. Welcome back to the Law and Crime Network, and we're going over the James Colley case, and that is a sheriff's officer, Sam DeLuca, who is actually one of the first responders, and we're here with Ashley Willcot out of Atlanta, who is a judge as well as a trial attorney, and we were talking about the kind of testimony that's going to have an impact. And it's funny, Judge, we were just talking about the emotional, they're going into these crime scenes. First of all, they don't know if it's completely safe. They're worried about their own safety, the safety of other people, and then you're coming and you're seeing this carnage, that's gone on there. I personally think he looked kind of affected as he was testifying about it. What were your thoughts?
Well, I think so, too. He was talking fast, and some of that, I think, mannerism can indicate that. But I also think that he was very law enforcement about it. They're trained, right? And so he was just recounting exactly what he saw. And I saw Miss Amanda, and she was laying on her back, and he described that. So, but I do think it was impactful and emotional.
Yeah, and I think that one of the things with these guys that are, most of the states use sheriff's officers to go as first responders. It's all different in different localities, especially down south. Is that the way they do it in Atlanta, that the sheriff's departments are pretty much the first responders?
It depends on the particular county. So in the rural small counties, the sheriff's office are the ones that do that. In the big metro counties, it's not the sheriff's office. But, the other thing I want to say about when they got to the scene, the thing that you said, carnage, and I would say bloodbath, same thing, right? And so you have to imagine it's not just going in and finding a body, it's finding this kind of carnage and the blood. And, one of the descriptions by one of the witnesses were the teeth were knocked out because the woman shot in the temple. And so that's really a descriptor to indicate it wasn't just a body. It was a pretty bloody scene.
Yeah, and I've always said to people too, it's one thing when you're in the antiseptic nature of a courtroom. You as a prosecutor, one of your jobs is to make that testimony pop. And there's ways to do it, because if you've been to one of those scenes, the smell of blood, the smell of gunpowder, when you're moving around, slippery slickness of blood when you're doing what it is that you're doing. And if you can try to impart that somehow in the testimony, it brings that testimony to life. And it's not just simply people that are testifying antiseptically about it. But we have another clip of a crime scene technician that we're going to talk about on the other end with the judge, and we'll go to that, and we'll throw it to that now. Thank you. Well, welcome back. This is a crime scene detective that is talking. I have Judge Ashley Willcot with us, who's been helping us with the commentary today. And this is usually people coming in after the first responders are there, and they're, what a lot of people don't get is it's not like TV. The minute that you know that the scene is safe and it's secured, it's a homicide case, pretty much everybody's backing back out of that scene, not to have all your DNA and trampling over the stuff. And then the crime scene detectives come in and methodically move into the main parts of the crime scene. But what's compelling to me, Judge, was the cell phone still in the left hand.
Right, absolutely. And that's scary because she was trying to get help. The other thing I want to point out is, this testimony is not only to prove the defendant did it, but also it's all about the chain of custody. I know you well know this, but for the viewers, it's the chain of custody. So the state has to prove that everything went through all of the right processes, procedures, and there was no opportunity for anyone to manufacture or tamper with the evidence.
Absolutely, Judge. Great point. Listen, we're going to cut to a break, and on the other end, we're going to come back with the judge and some more of this testimony on the Law and Crime Network. Welcome back to the Law and Crime Network. I'm on with Judge Ashley Willcot out of there from Atlanta, Georgia. Judge, that clip that they've got of that guy going after Nasser in the sentencing part of the hearing never gets old to me. And the sheriff's office is taking him down to court. I know you don't want that going on in your courtroom, but again, this is the kind of thing that you can understand given the emotional nature of those cases. And we're in a very emotional case here right now. Now, this next witness, and I can't wait for you to hear your great opinion here, Judge, especially as an expert in knowing evidence rules, just like hopefully we are as lawyers. You're the one that ultimately has to make the call whether you're going to admit evidence or not admit evidence based upon both sides arguing one way or the other. But this is a sheriff's officer who actually pulls a vehicle over, just to give context to our viewers, believing that it's Colley, but it turns out to be Colley's father. And the father gives damning statements to the police officer, and the sheriff's officer is then allowed to testify about them in court. We got that clip coming up, and on the other end of it, I'm just interested in what your legal thoughts are about the admission of that kind of evidence.
Yes.
Well, welcome back to the Law and Crime Network. Judge, are you still with us? I think it's, from what I understand offline, there's a lot of storm activity down there in Atlanta, and there's a lot of humidity up here in New York, and so there's a lot of signals and wires getting across. That was not the guy who we thought was going to be testifying about actually pulling the vehicle over. We're going to get to that at some point in time, but this gives us an opportunity to talk about these first responders and the hearsay rules and things about people making statements. So if you could just briefly, I don't want to put you on the spot for a law school definition, but explain to viewers what hearsay is, the exceptions or some of the exceptions to hearsay that would kind of allow that testimony that we anticipated was going to be played, that is the statement of the father about the son, to be admitted in the courtroom.
Sure. So when it comes to hearsay, you cannot have a witness testify to something someone else told them for the truth of the matter. And so they can't say what somebody else told them unless it falls into one of the exceptions. And so an example, for instance, is child hearsay and instances in which what a child said to someone might be admissible. We have, for instance, let's see, the excited utterance. So if you have someone who allegedly committed a crime and made an excited utterance, it falls within that exception and somebody can say what they said to them. Let's see, what else? Statement by party and interest. So certainly a person can testify as to what a defendant said to them. Those are some of the general exceptions. All
right, listen, folks, I have to be full disclosure here. The judge, she's sitting there, she's rattling this off without much she just knows it in her DNA as a judge, because you have to know these objections. You need to know it quickly. One is statement against interest, for example, but that's not a statement against interest of the father. Potentially, though, they admitted it through that somehow, and each state is a little bit different in their ability to admit evidence. So maybe there was some finding by the court. We're going to see if we can find that out on the Law and Crime Network. We got some great legal scholars that are in the back room. Was this argued? Wasn't it argued? Because essentially, by allowing it to come through, Judge, the police officer, it allowed the state not to have to call the father, who could probably be a sympathetic witness for his son.
And I'm sorry, I don't know what exception it might have fallen under, so I'm a little surprised it came in. The other thing to keep in mind as a judge, this happens all the time, the defense actually has to object to it, right? So if they didn't object, it comes in.
Yeah, and knowing these hearsay exceptions, and I say, Judge, also 404, you probably use the same kind of numbering system down there,
Sure,
other act evidence. Right, is the key to the tool belt of any lawyer. You have to know those evidence rules through and through. When they come out every year, I reread them just to keep myself up with respect to it, because you could have you could be the smartest person in the room. You could have the greatest facts in your corner. If you do not know how to legally admit that evidence, like my evidence professor in school said, that evidence isn't heard before the jury. And if the jury doesn't hear the evidence, you don't win the case. Have you seen lawyers that have tactically just failed to understand the evidence rule and killed their case?
More often than I'd like to tell you. It happens all the time. And not only that, do you know there's so many attorneys that I see defending that don't object. And so it comes into the record and they haven't objected. So for appeal purposes, they're not going to be able to appeal on those grounds. So it's frightening, to be honest, how much of that I see.
You know, Judge, that's a great point, too. We could go on and on, I could tell, based on our skill sets, because, you know, there are certain things that lawyers should be doing during the course of a trial to preserve the record, you know, on appeal. And when I was a young baby prosecutor, those judges were the smartest people in the room. They knew their craft. They taught you the craft. I'm seeing much more lackadaisical lawyering and judging going on.
You know, and it's interesting because it's almost like they've agreed ahead of time what's going to come in and what's not. I know that's not always the case, but it's really been interesting, the trials lately that we've been watching.
Okay, listen, we're going to go back. We're going to do a break, and unfortunately, we're going to have to end this show. Judge, we're not going to be able to show that clip, but it was fascinating having you on. You were an amazing guest. I love somebody who can rattle off hearsay rules like the back of their hand. Someday we'll get together offline, and we'll talk more hearsay. But, folks, listen, it's been a pleasure being on with you at the Law and Crime Network, and we'll see you the next time. I'll be back on Wednesday, 12 to 3.